if we have,
a
I
couple
apologize.
times, yeah.
If we have, I apologize
Yeah.
for my neglect.
Oh, no, I think ACS, when I was in law school, there were a couple ACS times with that.
Okay.
And then, well, there was, tailgate parties.
Oh my lord. Okay. Well, thank you for that information because it's been driving me insane.
Oh, yeah, we've done several times, yeah.
Oh lord. Okay, just in a different context.
Just, yeah, not.
Oh, way out of, yeah. Out of context.
Okay, Dean, am I going insane, or does Jesse look a lot like Fort Myers? Because when I saw him on Zoom, like, for a second, I was like,
There's probably some similarity, yeah.
maybe I just think all people that got some height on me look the same.
All tall people, yeah. Yeah, he's not quite as tall as Borgmeier, but yeah, there's some similarities there.
How are you liking the new gig?
It's a bit of an adjustment.
Yeah.
It's fun to get some good work.
Yeah.
What about you? When did you start with Brian Storage?
Right after school, so about 3 years almost.
Good gig, especially getting to learn all this from Dean.
Good morning. My name is John Clark. I'm the regulatory law judge presiding over this hearing. Today is May 24th, 2022, and we are in room 310 of the Governor Office Building. The Commission has set aside this time today for an evidentiary hearing in file number GC-2022-0158, which is captioned as Ozark Medical Center doing business as Ozarks Healthcare complaint versus Summit Natural Gas of Missouri Incorporated respondent. Now, we're having an in-person hearing today with at least one person participating via WebEx. I'm going to briefly go over some protocol stuff If you are participating via WebEx, if you're not speaking, I'm going to ask that you mute yourselves. Likewise, if you're participating in person and you're speaking, please be sure your microphone is on. That's the only way that the audio gets picked up. And if you're not speaking, I'm going to ask that as much of the time as possible that you have your microphone off. I'm also going to remind you, if you're participating in person, to please silence your phone. Now, commissioners may be participating today via WebEx, and they will certainly have some questions. They're free to interrupt me or any of the witnesses anytime they have a question. I may also have some questions. I'll leave some time aside for commissioner questions as well. Now, yes, I can. Thank you very much, Commissioner Holzman. I also see, at least from the WebEx, that we also have present Commissioner Maida Coleman. And as I said, other commissioners and Commissioner Roop. Good morning to all of you. Now I'm going to remind you, if you are participating via WebEx, that the WebEx chat function is not private, so please do not use it. And if you're participating via phone and you need to testify or ask a question, please use *6 to unmute yourself. At this time, I'm going to ask the parties to enter their appearance for the record, starting with Ozarks Medical Center.
Good morning, Judge. Caleb Hall appearing on behalf of Ozarks Medical Center, doing business as Ozarks Healthcare. My office is 230 West McCarty Street, Jefferson City, Missouri, 65101.
Thank you, Mr. Hall. And for Summit Natural Gas of Missouri?
Thank you, Judge. Dean Cooper and Jesse Craig of the law firm of Bryden, Swearingen, England, PC, P.O. Box 456, Jefferson City, Missouri 65102, appearing on behalf of Summit Natural Gas of Missouri, Inc.
Thank you, Mr. Cooper. On behalf of the Commission's staff.
Good morning, Judge. Jamie Myers on behalf of the Missouri Public Service Commission staff. My address is P.O. Box 360, Jefferson City, Missouri 65102.
Thank you, Ms. Myers. And on behalf of the Office of the Public Counsel.
Good morning, Mark Poston, appearing for the Office of the Public Counsel.
Thank you, Mr. Poston. We have a court reporter that is not in person today, that is appearing via WebEx. Ms. Lammert, if you need somebody to repeat something, please interrupt me and let me know. At the same time, because I don't believe the court reporter can or may not be able to see clearly who's speaking, I'm going to ask that before you speak, if at all possible, you announce who you are, just so the court reporter can pick that up. Now, as a brief preliminary matter, there is some information that was filed in this case that is highly confidential in nature. If we are going to be discussing confidential or highly confidential information, I'm going to be relying heavily on the parties to let me know so that I can go in camera for the purpose of doing so. So if it's obvious to me, I will go into camera, but if you are aware that you're going to be talking about something that we need to go in camera for, please let me know. Are there any preliminary matters that need to be addressed by the Commission at this time? I see no one speaking up, so I will assume at this time the answer to that is no. I'm going to follow the order of openings as submitted by the parties, and that means we will hear openings first from Ozark Medical Center, then from the Office of the Public Counsel, from the Commission staff, and finally from Summit Natural Gas of Missouri. So, Ozark Medical Center, would you like to make an opening statement?
Yes, Your Honor. May it please the Commission. Caleb Hall appearing on behalf of Ozarks Medical Center, doing business as Ozarks Healthcare. For purposes of the record, I may refer to Ozarks Healthcare as Ozarks throughout my opening statement and the rest of the proceedings today. Commission, this case is about finding a solution to an otherwise insurmountable problem. The problem being that Ozarks Healthcare is being asked to pay nearly half of $1 million for 1 month's use of natural gas, or else face a potential shutoff or curtailment in service. The Commission can resolve this problem through one of two potential means. 1. Issue an Accounting Authority Order, or AAO, to track and defer the disputed bill to Summit Natural Gas's next rate case. Or 2. Direct Summit to accept a payment arrangement with a manageable timetable that the hospital's financial streams can sustain. An AAO is justified in this case because Winter Storm Uri and the precipitating disputed bill in this case are extraordinary events, and granting a deferral in this instance will permit Summit to continue collecting all of its winter 2021 natural gas costs, including those in controversy here. A payment plan is also a proper remedy because Summit's tariff contemplates that payment arrangements be available for special circumstances. Considering this is their first foray into this environment, I feel the need to introduce Ozarks for the Commission. Ozarks Healthcare is a nonprofit healthcare facility that's been serving the West Plains community for the past 60-some years. When the hospital first started in 1959, it employed 60 people and used 42 beds to treat about 40,000 people a year. Today, the hospital employs over 1,300 people to treat 364,000 people annually, including additions of 5,000 people for inpatient long-term care. For perspective purposes, the population of West Plains is only around 13,000 people, and the larger Howell County in which it sits is just over 40,000. From its main campus and surrounding clinics, Ozarks Healthcare provides services to 6 Missouri counties and 2 in northern Arkansas. This translates to around 108,000 Missourians and 53,000 Arkansans. For these people, Ozarks Healthcare is the only realistic provider for inpatient care. Should they need to seek services elsewhere, they would need to drive 100 miles in either direction. This proximity of Ozarks Healthcare and its unique nature as being the sole inpatient provider for these people is why disconnecting Ozarks Healthcare is such a problem. Ozarks' access to gas is directly connected to the public health of the surrounding community. Allow me to explain in this case. At this point, I think we can all attest to the severity of Winter Storm Uri last year. Given popular reporting and this commission's multiple public investigations, we don't need to belabor that Winter Storm Uri was extraordinary. The continental U.S. experienced a week of prolonged ice and frigid temperatures that were extreme even by Midwest standards. From February 13th to the 17th of 2021, temperatures hovered anywhere between 19 and negative 15 degrees Fahrenheit. Local snow depth reached 7 inches, and local gas companies experienced price increases anywhere from 17 to 247 times first of the month prices for February 2021. In short, it was a freak storm. This context is important because while Uri raged across the state, Ozarks Healthcare was using natural gas. Like other transportation customers, Ozarks Healthcare uses natural gas primarily for heating. But importantly, and different from other customers, the hospital uses gas as a means to sterilize medical equipment for inpatient procedures. February 2021 also marks the time when the state was experiencing a surge in pre-vaccination COVID-19 cases. As a result, Ozarks Healthcare was at capacity for both in and outpatient treatment while the storm was going on. Further compounding factors is that the hospital's backup propane supplies failed at the same time. When gas prices increased, Summit Natural Gas asked several customers to curtail their use to mitigate any cost exposure. Ozarks responded to the call and began relying on its backup propane. However, and unfortunately, the temperatures were so extreme that Ozark's backup propane reserves failed for what appears to be the first time in recent memory. Without a backup reserve, Ozarks Healthcare was unable to mitigate its exposure to increased gas prices, and at that moment it faced two choices: continue curtailing natural gas and reduce medical operations, or prioritize its obligations to the public and meet adequate health standards. Ozarks chose the latter and continued to use natural gas throughout the 2021 winter storm. Now, Ozarks expected its bill to be higher. Winter bills always tend to be higher than summer bills, especially when you're dealing with gas. However, what the hospital got was leagues beyond what was reasonable or what could have been expected. Its gas bills usually range anywhere from $15,000 to $20,000 in the winter months. What Summit Natural Gas demanded, though, come March, was nearly $500,000, specifically $463,336.84 for 1 month's use. The bill did not explain how roughly $400,000 of a, quote, cash out imbalance was calculated, or explain the discrepancy between this figure and the several thousand that Ozarks would normally see. After Summit sent this bill, there was back and forth between the parties. There was a threatened disconnection, which Summit has graciously forestalled throughout the pendency of this case. However, Summit is still demanding this sum. The issue, and going back to the problem in this case, is that there's only so much blood you can squeeze from a stone. 2021 was a hard year for most, but especially so for healthcare providers. Without federal funding in response to COVID-19, the hospital would have lost over $10 million. Add on this disputed bill, and the financial impact creates a potential risk for patient care. Every dollar that Ozarks makes goes back into the community, not shareholders. When you take $500,000 out of the hospital for inflated gas prices, you're taking money away from salary, preparation for future patient needs, and necessary equipment. This is where you come in, Commission. Ozarks still maintains that the bill does not accurately reflect the cost to serve the hospital. That being said, Ozarks Healthcare is asking for two potential solutions to this problem. As aforementioned, our first request is that you authorize Summit to track and defer the disputed cash-out imbalance as a regulatory asset through an AAO. An AAO is a tool that the Commission has used to permit utilities to track and defer extraordinary costs for future cost consideration in subsequent rate cases. The Commission has historically followed the Uniform System of Account standards to grant AAO requests when the costs at issue are unique, unusual, and not likely to recur. All of these traits are present in this case. Rarely, if ever, will we see the culmination of a freak weather event, unprecedented natural gas prices, an unexpected backup propane reserve failure, and all of this, mind you, coming together during a once-in-a-lifetime pandemic. Issuing an AAO in this case will not change Summit's rates now, and it isn't retroactive rate making, but it will preserve the cash-out debt for future consideration in a rate case where the financial impacts to Ozarks Healthcare and the community at large can be minimized. How do we know that the impact will be minimized through an AAO? Because we can see the impact right now. During the pendency of this case, Summit had to readjust its purchase gas adjustment clause to account for its winter 2021 costs, including the amounts that are disputed here. I don't wish to get into confidential numbers, but I ask the Commission to turn to page 6 of Mr. Reeves' rebuttal testimony. There he lays out the numbers that are in dispute in this case relative to the amounts that are currently included in the PGA and that are currently being charged to customers over a 5-year timetable. It is ultimately a small fraction of the total cost that is included within the PGA, but it represents a massive benefit for Ozarks Healthcare and the surrounding community that it serves. Alternative to this AAO request, Ozarks asks that the commission exercise its authority per Summit's tariff and its general rate-making powers to order Summit to accept a special circumstances payment arrangement that is manageable on Ozarks' revenue streams. Our recommendation is one where Ozarks will pay 10% of the total disputed amount within 30 days after a commission order, and the remainder in equal monthly installments over a 10-year period. For all of these issues that I've mentioned, Ozarks Healthcare sponsors the testimony of Josh Reeves. He has worked for the hospital for the past 7 years and currently serves as its Vice President of Development and Advocacy and Director of Facilities. In that role, he oversees the main campus, its energy purchases, and can speak directly to Ozarks Healthcare as an institution, its role in the community, and the failure of its backup propane reserves. At this time, I am available to take whatever questions the commission may have, but I also remind the commission that Mr. Reeves will be up on the stand shortly, and he may have a few more intelligent answers than I can provide.
Okay, thank you, Mr. Holm. I do have a few questions. As you pointed out, there were two issues put forth by the parties today for the commission's determination. And one involves whether we should address Ozarks cash out balance by authorizing an accounting authority order, or AAO as you referred to it, and the other was whether we should address it via payment plan. In my mind, the parties are free to argue otherwise. This appears to be two essential actions, one being a complaint and the other being a third-party AAO request, which is being offered as a potential remedy. So starting with this as a complaint, what does Ozark believe the violation is on which the complaint is premised? Because I believe the complaint statute says that any person, entity can make a complaint about anything done or not done that violates a tariff, order, rule, or law, which would be subject to the commission's authority.
That's a great question, Your Honor. By commission rule, when there is a billing dispute when there's a billing dispute, the utility cannot move forward with a disconnection. Once we receive the disconnection notice from the company, and they were moving when they were moving to proceed on disconnection, that was the violation. There was still a billing dispute. The hospital still contends that the bill that was sent to it does not accurately reflect the costs that Summit actually incurred to serve the hospital. Secondly, I would offer that when a third party is asking for an AAO request, recent commission practice has been to file these type of requests as a complaint proceeding. Even though in this circumstance, it's a bit unique in that we are offering a proposal for Summit to receive all of the money that's actually in dispute here.
Okay, thank you. In regard to that, you say that it's basically an inaccurate bill and a wrongful shutoff action, as well as, I believe your complaint indicated a violation of their clause in their tariff sheet 37. Is that correct?
Correct.
Or does the Ozark not consider that a violation at this point?
We believe that that tariff provision authorizes Summit to provide for payment arrangements in special circumstances, and that Summit has otherwise unreasonably withheld that option from Ozarks Healthcare. And so we did allege that a violation of that tariff in our complaint, yes.
Does Ozark believe that the commission has the statutory authority to order Summit to provide a payment plan?
Yes, Your Honor. Not only is there the tariff provision, however, we are also relying upon the commission's necessary and proper powers. I forget the citation at this time, but it is provided in our position statement.
Okay. And you believe it's a violation of the company's tariff if they don't enter into a payment plan with you?
Correct. In this instance, where we have clear special circumstance by any plain definition, plain interpretation of that phrase, in this case, the company was being unreasonable.
Is Ozark asking the commission to waive or nullify this amount?
No, we don't believe the commission has the authority to waive full recovery of this amount. Some cost was incurred by Summit. We ultimately dispute that it was the 500,000 figure that we're seeing here. But when looking at what options are available to the commission, we came up with these two. The elegance of them is that they provide relief for both Ozarks Healthcare and Summit Natural Gas.
Now, you're alleging that that Ozark was improperly billed. Is that correct?
Correct.
Are you alleging that the transportation rates of Summit are not just and reasonable?
No.
In regard, and this is just a question I have in regard to an AAO, because is it your understanding that an accounting authority order under that provision, Ozark would not have to pay this amount back? Is that correct?
Correct. Our understanding is that once the commission authorizes the AAO, Summit would not be seeking that payment anymore from Ozarks Healthcare. Instead, Summit will be able to continue collecting the disputed cash out debt through its PGA that's currently ongoing. You'd have an active AAO that would then continue until the next rate case. At that time, depending on when Summit files its next rate case, you can either provide for recovery for the utility, depending on the difference between what was collected in the PGA and what has remained to be collected through the AAO. Or, I mean, this is a happy circumstance. Assume that Summit has collected all the disputed cash out debt through the PGA by the time Summit comes in for the next rate case. Then there's no action to take with the AAO. It can effectively be written off the books because the amount of money in dispute has already been collected.
Say that again, please. Say that last sentence.
Sure. And this is all, I don't wish to speculate, but imagine for a moment the commission authorizes the AAO, but the PGA that is currently effective remains in place. If Summit continues to collect through the PGA, continues to collect the cash out debt through the PGA, and collects the entirety that's in dispute in this case by the time Summit initiates its next rate case, the AAO is still effective, but then the question to the commission is what to do with the AAO. If Summit has already collected the full amount in controversy through the PGA, then the proper thing to do with the AAO would be to recognize that recovery has already been had and effectively wipe the AAO from the books.
Under either of those propositions, either the AAO or collecting it through the PGA, where Ozark is not directly providing payment for service, do you believe that violates the filed rate doctrine?
No more than deferral accounting has otherwise violated the filed rate doctrine in the past. I don't wish to speak for things that are outside the record, but I asked, we can turn to Summit's last rate case, GR 2014-0086. And in that case, I believe the commission has authorized deferral accounting for energy efficiency programs. And I forget the case number at this time, but if the commission would turn to the joint stipulation of facts from the parties, we do acknowledge that Summit is also covering another tracking device for the benefits that came from the Tax Cuts and Jobs Act.
What I'm saying is those are spread over a wider, I mean, usually an AAO is tracked as a regulatory asset, or in some cases a liability. But it usually encompasses some sort of company-wide bill, which would be spread over all of the ratepayers. In this case, you're asking to take a single party's bill, and that's why I'm asking if it violates the filed rate doctrine.
Respectfully, Judge, I don't believe this would violate the filed rate. I do not believe this would violate the filed rate doctrine. Consider the PGA itself. Normally, without the inclusion of transportation customer costs, it's the amalgamation of sales customer costs and spreading that out amongst all the sales customers. You might have neighbor A that uses far more gas during a winter storm than neighbor B, but you don't distribute their PGA costs in some type of equitable fashion. Instead, it's all grouped together and spread out amongst all the sales customers. that even though neighbor B is effectively subsidizing neighbor A, that has not violated the filed rate doctrine. Similarly, when this commission authorized an AAO to account for the retirement of the Sibley power plant that Evergy was operating, I believe, now, I don't want to misquote people that aren't in this room that to defend themselves, that can't defend themselves and aren't in this room. However, one issue that was brought to the appeals court was whether or not an AAO in that case was somehow a collateral attack on the rates that had previously been approved. The Western District Appeals Court disagreed. I believe that holding is applicable here, or at least analogous to the type of dispute we have.
Okay, and I think the last question I have right now is, do you believe it's unjustly discriminatory if an accounting authority order is granted to distribute a bill that is Ozarks over the company's rate, other rate-paying customers?
Your Honor, I'm glad you asked that question because it does get to an undercurrent of this case. You said unjustly discriminatory. The phrase unjustly discriminatory almost implies that there is some amount of discrimination that's proper. And in this utility world, unfortunately, there is no free lunch. We have energy efficiency programs that are subsidized, where non-participants are subsidizing participants. You have disputes over whether or not cost allocation is done equitably amongst rate classes. We wouldn't be asking for an AAO for any type of cash out, and you should not approve an AAO for every type of cash out dispute that happens. The reason why we're asking for one is because, per the commission's test and per the AAO standard, this is extraordinary. Ozarks Healthcare isn't just any transportation customer. It's a transportation customer that effectively can't curtail use like other transportation customers. It wasn't just a bad storm. It was a bad storm when backup propane supplies failed, when COVID-19 was surging in the state, and when gas prices were higher than what had seen possibly, if ever, when gas prices had rise to levels potentially never seen before.
Are you aware of any other instance where the commission has allowed an AAO or a payment plan when a customer has been unable to pay their utility as a result of an extraordinary event?
I believe you can find examples of the commission approving stipulations that have been entered into between parties. In our research, we have not found a previous case where the commission has issued an AAO in response to a payment dispute.
I know that Ozark has not requested this. Do you believe the commission could grant Ozark some kind of emergency interim rate relief?
I admittedly have not researched that type of question, and I would need to confer with my clients to see what type of interim rate relief could actually be could still meet the needs of the hospital.
Okay, thank you. Any commissioners have questions for Mr. Hull? Okay, I hear none.
Judge, I apologize to the commissioner, but I'm not able to hear the commissioner here in the courtroom.
That makes two of us. Hold on just a moment. I'm sorry, Commissioner Holzman, can you speak again and just a little bit louder, please? Thank you. We're just having some difficulty getting questions from the WebEx over the speakers. I can hear you, yes. Do Commissioner Roop or do Commissioners Roop or Coleman have any questions before Go ahead, Commissioner Holzman, with your question, please.
Commissioner Holzman, I don't mean to interrupt, but I want to make sure that the stenographer heard your question, that we've got all the AV stuff handled. Ms. Lambert, can you confirm that you're able to hear the commissioners?
Yeah, they're not having problems over the WebEx. We're just having a problem in this room.
Okay, as long as it's a one-way issue. My apologies, Mr. Holzman. I'm getting indication from Mr. Reeves in the back room that he can speak to that question.
Okay, then. Thank you, Commissioner. I'll try and remember to prompt you during Mr. Reeves' testimony. Any other commission questions at this point? Okay, thank you, Mr. Hall. You can step down. Next opening statement will be from the Office of the Public Counsel. Mr. Poston.
Good morning. May it please the commission. My name is Mark Poston. I'm here on behalf of the Office of the Public Counsel. As Mr. Hall just described, there are two basic issues: the request for an AAO and potential payback terms. And I'll start with the payback terms. We ask that you resolve this complaint by ordering a reasonable length of time for the hospital to pay its large bill due to Storm Uri imbalances. The hospital provides a valuable service to multiple counties in Southwest Missouri, and the payback length should be consistent with the hospital's ability to pay. We don't have a preference for the period, and we defer to the hospital for providing evidence on what it can afford. Of course, the appropriate interest rate is also an issue that's not really been discussed much. Setting a very low interest rate is another way the commission could help the hospital avoid further negative impacts. In Summit's separate PGA ACA case, where interest is an issue, and I believe it may be the only issue right now, the OPC intends to file testimony from its finance expert, Mr. David Murray, in that case regarding an appropriate interest rate to apply to the Storm Uri costs. But unfortunately, that testimony evidence is not available for this hearing. Regardless, it could help the commission to deliberate on this complaint and the PGA case together, since these issues are related. Regarding the hospital's request for an AAO, we ask that you deny this request. Ozark is clear in its position statement that the entire purpose of their AAO request is to have other customers pick up Ozark's bill. Requiring other customers to pay the hospital's bill is prohibited by Section 393-130 and 393-140 of the Missouri statutes that prohibit discriminatory and prejudicial rates. And it would violate Summit's tariff for transportation service and how to address imbalances. In Summit's position statement, they also raised the takings clause, and we would agree with that as well, that would be a concern here. I've not researched the filed rate doctrine, but I will look into that before we file briefs to see if that is an issue here as well. So we believe Ozark's AAO request is not a lawful or reasonable solution to the hospital's problem here. No other customer should be responsible for the hospital's bill. And that principle should be the starting point for whatever the commission decides in this case. Summit's other customers, Missouri's homes and businesses, are already paying for the impacts of Storm Uri. A better solution, a more fair solution, is to order repayment terms that allows for an extended payment period for the hospital. That's all I have. Thank you.
Okay, I've got a few questions for you. I know that while public counsel is opposed to an AAO, and I will probably ask this question again of staff as well. Hold on just a moment. In regards to an accounting authority order, my general understanding of an accounting authority order is it allows to take an amount that is owed or an amount that is in excess and basically set it aside for consideration in the company's next rate case. Is that correct?
That's correct.
Is there anything, and an AAO, as I understand it, is not a creature of statute. And so is there anything that would prohibit, in your mind, an AAO porting the amount over to a rate case and then determining in rate case that Ozark has to pay back that amount over a set period of time?
Well, I'd say look at what they're actually requesting, the type of AAO that's being requested here, and that's not what they're really requesting. What they're really requesting is that they just be relieved of their obligation to pay this and that other customers pay it. And so that's what, they're not asking for an AAO where these decisions will be decided in the rate case. They're wanting you to make that rate decision here. And we believe that is prohibited that's not appropriate use of an AAO.
And I would agree that they're not asking that. I'm just thinking outside the box. Do you believe that that's something the commission would have the power to do, or is that something you just don't want to speak to?
Would they have the power to defer these amounts to an AAO and consider it? We have fought AAOs in the past in the courts, and we have lost, so I would say they probably do have the authority to defer this. I just wouldn't know what the purpose to do that would be.
I was actually more interested in the second part. If it were deferred to a rate case, would the commission have authority to then make Ozark and Ozark alone pay that amount back? Or, in the alternative, the transportation customers as a class and not spread it over all of the ratepayers?
I do not believe the commission would have the legal authority to transfer this debt to another customer, even within the same class.
Now, public counsel is encouraging the commission to order a payment plan. Is that correct?
We believe that, that could help the hospital situation, yes.
Does public counsel believe that the commission has the authority to order a payment plan?
I have not researched that, but I will say, I think the commission has very broad authority when it comes to rates and billing. And so I do believe that they do have the authority. But again, I have not specifically researched that issue.
If the commission ordered Summit to provide a payment plan, would that violate the takings clause?
Ordered Summit to
Provide a payment plan in the length that is being requested by Ozark.
takings in the sense that it would possibly be taken from Summit? Or,
Yeah, property.
well, I guess it depends on whether they would collect the whole amount and require Summit to eat a portion of Ozark's bill.
Now, because this is a complaint case, do you believe that the commission would have to find a violation of tariff, order, rule, etc., in order to order a payment plan?
I don't know what the legal argument would be that they could not order a payment plan, and because this is a complaint case. So I believe they could, but it's another issue I've not researched to see whether complaints are more narrowly construed than that.
Okay, I don't have any other questions at this time. Are there any questions from the commission? Hearing none, we will, thank you, Mr. Poston. You can sit down. And we will hear opening statement from our next party, which is the staff of the Public Service Commission.
Well, good morning and may it please the commission. My name is Jamie Myers, and again, I am here representing the staff of the Missouri Public Service Commission. Staff witnesses David Sommer and Kimberly Bolin have sponsored and pre-filed rebuttal testimonies that address some of the issues in this case. Mr. Sommer and Ms. Bolin are here today to answer questions, but just briefly, I'll give an overview of staff's position and also hopefully answer some of the judge's questions. First, staff recommends the commission deny Ozark's request that the commission authorize or order Summit to track and defer Ozark's unpaid bill, which primarily has been attributed to Ozark's cash out imbalances. Essentially, what Ozarks is requesting from the commission is an accounting authority order that would allow Summit to defer Ozark's unpaid bill and reserve that amount for consideration in Summit's next general rate case. AAOs have usually been used in Missouri to allow utilities to capture certain unanticipated costs that have not been included in ongoing rate levels. Historically, the Commission has authorized AAOs when the costs in question were associated with an event that is extraordinary, unusual, or unique in nature and not expected to be recurring. Typically, the costs in question have also been material. Importantly, the authorization of an AAO is not a guarantee that the utility, or in this case, Summit, will recover the cost included in an AAO. Recovery is determined in a subsequent general rate case. AAOs deviate from the Commission's general rate-making methodology, and because of this, staff recommends the Commission only utilize AAOs in limited circumstances. While Storm Uri, the event itself, was extraordinary, Ozarks choosing to take on the risk of being a transportation customer and further being unable to minimize its cash out imbalances is not an occurrence staff recommend should warrant the use of an AAO. Further, as noted, the authorization of an AAO does not guarantee the recovery. Now, in its pre-filed testimony, Ozark has clearly asked that in Summit's next general rate case, that its bill, if deferred, be paid by all of Summit's retail ratepayers. Conceptually, staff opposes this, but the Commission is not in a position to make that determination in this case. Instead, what would happen is in Summit's next general rate case, the costs of Ozark's unpaid bill, should the Commission decide they are appropriate for recovery, will have to be allocated. Given that it's not possible in a rate case to allocate a specific cost to a specific customer and therefore charge only that specific customer, in all likelihood, the cost of this unpaid bill would have to be allocated to all customers within the transportation class, which Ozarks is a member of, or possibly even allocated to all of Summit's customer classes. Now, staff acknowledges Ozark's important role and the significant dollar impact of this bill. Staff recommends that a preferable solution would be a payment arrangement that allows Ozarks to pay its owed bill over time. Now, Ozarks has requested a payment arrangement with terms that would allow it to be paid over 10 years. Staff, however, would more likely support a payment arrangement that results in Ozarks paying its balance in no more than 5 years. Again, staff witnesses David Sommer and Kimberly Bolin have sponsored and pre-filed rebuttal testimonies here today and are here today to answer questions on this topic. David Sommer is the pertinent staff witness for questions regarding the ACA or PGA. Kimberly Bolin is the pertinent staff witness for questions regarding AAOs and general accounting treatments. And with that, Judge, if you have any more questions for me, I am also available. Thank you.
Okay, thank you. Does staff believe the commission has the authority to order a payment plan?
Judge, standing here today, that's not clear to me. I agree with Mr. Poston's remarks. That's something that we probably staff needs to research and appropriately brief. I will say I disagree with Ozark's counsel that the commission can rely on tariff sheet number 37. I think the plain language of that tariff sheet says it's within the company's sole discretion to enter into these special circumstance payment arrangements. But further, what other authority the commission may have to order a payment arrangement, I think that's something that I could appropriately brief.
Okay, do you think that as a complaint case, the commission would first have to find a violation in order to do so?
Well, again, should the commission have the proper statutory authority to order a payment arrangement, I think that on itself is enough. And I say that because, again, the dispute here tends to be what would be the appropriate payment arrangement, the payment terms, and that itself is a dispute. So I would say, again, just relying on that statute itself that would allow the commission to order a payment arrangement would be enough.
Why is staff encouraging a 5-year as opposed to a 10-year payment plan?
Again, this might be a good question for Mr. Summer to ask as well, but a lot of these costs are already being paid through the PGA. And so to the extent that this lingers on, customers are not getting credited back through the PGA clause. So again, that was kind of our benchmark of no more than 5 years.
Did staff do any, if the commission were to grant an accounting authority order, has staff done any analysis of what the rate impact would be?
So, Judge, we have not. That's going to highly depend on how the costs are allocated. Are you allocating to one specific customer class, like the transportation class? Are you allocating to multiple classes? Again, it would highly depend on how they're allocated. And, again, also things are carrying costs allowed and things like that. So short answer is no, we have not.
Okay. If either the commission were to order or the Summit and Ozark were to agree to a payment plan, is interest appropriate?
Again, I think it depends on the terms. If it's an immediate payment that resolves the dispute, interest may not be appropriate. If it's going to be a longer time period, again, to make Summit whole, which ultimately would make the retail sales customers who are already paying this whole, or the firm sales customers who are paying this whole, then interest would be appropriate.
Are there any other, well, let me ask it this way. Did Summit, to your knowledge, receive any special commission treatment due to Winter Storm Uri?
So I know Summit, in particular for its PGA clause, does have an extended recovery period to spread those costs over a longer period of time. Again, that's that is a customer benefit. Beyond that, off the top of my head, I cannot think of any other special relief that Summit has been granted.
Summit doesn't have an AAO for any of these costs.
I don't think Summit does, no.
And I'll be asking them that
Yeah.
question too. So I was
Yeah.
just asking to the best of your knowledge. Are there other utilities in Missouri that have received a special commission consideration due to impacts of Winter Storm Uri?
I don't know that they have received it yet. I know that on the electric side, there is a statute that allows for securitization of these costs, and I know that there's at least 2 utilities that are pursuing that right now.
Are there any questions from the commission? Go ahead, Commissioner Holtman.
Thank you. Can you talk a little bit about verification of the sheriff penalty and that $500,000 amount? How much of that is
Okay, so I cannot answer that exact question. I know staff witness Dave Summer is more familiar with the tariffs and how the penalties operate. Um, so I can't say specifically how much of the total bill that's owed now is because, and I apologize, it's because of cash out imbalance fees or because of late fees. So again, I apologize, but that might be something to maybe David Summer from staff could answer, or possibly Summit's witness as well.
Are there any other commission questions at this point? Go ahead, Chairman.
Just to clarify, outside of securitization, your testimony was no other utility has received any special consideration for Winter Storm Uri. Yeah, is that correct?
Well, on the gas side, I believe all of the gas utilities on their PGA tariffs are now spreading the cost over longer periods of time. I think it's anywhere from 3 years to 5 years are the extended periods of time, and those are all the gas utilities. But costs beyond that, and again, setting aside the securitization cases you mentioned, I'm not aware of any special relief. Yes, I would say it is.
Thank you, Chairman. Are there any other commission questions? Okay, thank you, Ms. Myers. You can step down. And our final opening statement this morning will be from Summit Natural Gas of Missouri. Mr. Cooper.
Thank you, Judge. Dean Cooper on behalf of Summit Natural Gas in Missouri. OMC, I think it's been noted so far, is authorized to receive natural gas service as a transportation customer under Summit's tariff. Customers who elect transportation service must manage their own gas supply needs and must secure natural gas supply either directly from a pipeline supplier or through the use of a marketer broker who secures supply from a pipeline supplier on behalf of the customer. The cash out provision of Summit's tariff addresses the treatment of a transportation natural gas customer's imbalance between its use of natural gas and the actual amount of gas it has delivered on a monthly basis. If a transportation customer uses more gas than is delivered to Summit's system, this is a negative imbalance, and the cash out provision requires a transportation customer to pay for the gas that Summit must supply in its place. The charges at issue in this case have been calculated in accordance with Summit's tariff. The negative imbalance amount at issue in this case is the result of OMC's use of more gas than it delivered to the system in February of 2021. In other words, during that month, Ozarks, or OMC, was using natural gas purchased by Summit on behalf of its firm sales customers. Ozark's net nominations for the month of February 2021 were 2,413 decatherms, but its actual consumption was 3,639 decatherms, which resulted in a shortage or negative imbalance of minus 1,225 decatherms, or as the company computes it, a negative imbalance of 33.67%. Now, for perspective, Summit's tariff identifies 15% and over as the highest level of imbalance. So a 33.67% negative imbalance is fairly significant. It's probably also worth noting that this is not an operational flow order or OFO case like the Commission may have seen in other circumstances. This is, Summit never did issue an OFO in February of 2021. So this is just a standard cash out provision under Summit's tariff that would take place any month during the year. Mr. Hall focuses on Ozark's usage during this period of time, February of 2021. But again, because this was just a standard cash out situation, Ozarks had until the end of February to be in balance. Many of Summit's transportation customers used that opportunity to get back in balance by the end of the month. Ozarks did not. One other matter that I think I would note, and this may come up in questioning of the witnesses later, because Your Honor had indicated some interest in the portions of the bill and that sort of thing. I want to note that the amount that's identified as in controversy in the stipulation of facts as owed as of January 12th of 2022 is an amount that represents all amounts that were owed as of January 12, 2022, not just amounts due to the events of February 2021. So I think that's a distinction that we probably need to make as we move forward through the case. As to the list of...
Can you clarify that for me?
Yeah, what I am seeing, and I think I can see it first from Mr. Reeves' direct testimony and the recap of payments and that sort of thing that happened. That's represented, I think it's Schedule 3, but there are amounts billed for other months that have not been paid. So that's what I mean by the fact that the total amount owed by Ozarks is more than just the amounts associated with February of 2021. And of course, there would be late fees and some other things that would necessarily be considered to be a part of that February 2021 amount that was billed in March. But there are other amounts billed since then that have not been paid. Does that help, Your Honor?
It does, which brings me to my next question, and I'll let you get back to your opening. I'm sorry to interrupt, but in regard to these amounts, who would be the appropriate witness for me to ask for a breakdown of these amounts in terms of what is, what's carryover from previous or other months, what is related to the Winter Storm Uri February usage, how much is penalties and late fees, and also, what in regard to, who witness would I ask in regard to what the actual costs to Summit were?
Well, I think it's a combination of our witnesses, Mr. Markham and Mr. McCarter. We do have, because you suggested that you would be interested in this, we do have a schedule that one or the other or both can probably talk to that lays out everything really from that February 2021 associated March bill through present day that would kind of lay those things out, I think.
Now, in regard to these breakdowns, are those amounts that should be discussed in camera?
I think it's a question for Ozarks ultimately.
We would ask that remain confidential, and I also believe by commission rule, this customer information would all be presumed confidential. So we would request an in-camera proceedings for any discussion of those numbers.
Thank you, Mr. Allen. That's fine. I was just asking because then the 500 or 400 something thousand number has been bandied about quite a bit. I just wanted to see where the line is.
I think that number has been public all along, hasn't it?
The cash out debt in dispute, yes.
Okay, thank you. Go on, Mr. Cooper.
Fairly briefly, I'm kind of to the list of issues itself, but not surprisingly, and as stated in our statement of position, Summit believes that the Public Service Commission should not address Ozark's cash out imbalance by authorizing or directing Summit to track and defer the imbalance as a regulatory asset for recovery in its next general rate proceeding. There's been some discussion around this as well, but the consequence of such commission action would be to at least potentially require Summit to carry this amount on its books perhaps without payment until new rates are implemented following the company's next general rate case. It would potentially require Summit sales customers, who you may be familiar with their service territory, but it runs from almost to the Iowa border in Gallatin and Hamilton to almost the Arkansas border on the south has been referenced by Mr. Hall and the Ozarks service territory for the medical facility extending into Arkansas. I think that many of those customers, most of those customers, are well outside Ozarks service area for its medical services. Additionally, there was the takings question. We had stated that we would believe that this AAO would violate the takings clause. And at least on one level, that's because if such an AAO were issued and upheld, you're taking amounts that today are owed to Summit by this customer, and you're turning that into an accounting mechanism for consideration in that next rate case. I mean, that's really the problem, is that an AAO is not a guarantee of recovery. It merely provides for consideration in that next rate case. And so I think you really have taken, again, you've taken dollars that should be paid to the company under its tariff provisions, and you've turned them into something that maybe they'll get, maybe they won't get in the future. And in fact, the nature of the AAO and the court cases about that indicate that an AAO is no guarantee of recovery. So that is a significant problem with the AAO approach. As to the second list, or the second listed issue, we also believe the Public Service Commission should not and may not order Summit to address Ozark's cash out imbalance through a separate payment arrangement. Certainly the company has talked about that, and I think it may continue to talk about that with Ozarks, but I don't think there's any authority in this tariff or otherwise that would permit the ordering of a payment plan in this situation. Having said that, any payment arrangement for Ozarks, we believe, should require variable interest equal to whatever is being charged through the ACA process for Summit for under-recovered gas costs in order to keep Summit's sales customers whole, again, many of which are located far and away from the site of the Ozark facility. Summit will present two witnesses today. I referenced them earlier, Mr. Phil Markham and Mr. Walt McCarter. Mr. Markham will appear in person today, and Mr. McCarter will appear by WebEx. And that's all I have, Your Honor.
Okay, thank you. In regard to the takings clause and an AAO, you're saying because it's speculative, assuming that an accounting authority order were granted, and wouldn't the determination of whether it was a taking occur dependent on whether or not Summit did receive that amount back with the appropriate interest?
Ultimately, that would be the test of whether certainly Summit received the dollars or not. But in the interim, I think that the government in that situation, again, has taken dollars that are owed to Summit that it could pursue through the process established under its tariff for trying to recover those, to include discontinuance of service, or, in the alternative, it can today file a civil suit against Ozarks if it so chose to try to recover those dollars. The effect of the AAO would be to take all those rights away from Summit and leave it really sitting and waiting to see what might happen at a point in time that could be years away.
And you indicated that you do not believe the commission has the authority to order a payment plan. Why not?
Well, I agree with the others. I haven't found so far any authority one way or the other. But I think that, first off, I don't think that sheet 37 provision is actionable in this situation. I don't think it justifies a commission order of a payment plan, specific payment plan. But I also don't know of any other provision in commission rule or statute that refers to that. So I guess I'm operating from the sort of the general position for the commission that unless it has been given the authority, it doesn't have the authority.
Now what Summit is seeking at this point in time is for Ozarks to pay the complete amount in one payment. Is that correct?
Well, I'm struggling just a little bit with your question, Your Honor, because
Well, then why don't you tell me what?
Yeah, it starts to invade a little bit, I guess, settlement discussions between the parties.
And I certainly don't want to do that. Then let me ask it a different way. What is Summit seeking from the commission in regards of an order of this, in this case?
I think Summit is seeking to the extent it's a complaint, denial of the complaint, and to the extent that it's a third-party request for an AAO, denial of that request. I think it's that simple for us.
And then Summit would have the authority to collect, or Summit would be authorized to collect the complete amount if they wanted to.
Correct.
I'm going to ask you a few questions about tariff sheet 37, and I may also have those questions for witnesses as well. Now, there's a clause in there that was referenced in the complaint that the company, it says the company reserves the right to, and at its sole discretion, enter into separate imbalance agreement with shippers that take into consideration special circumstances. Has that clause been used before by Summit to grant special circumstances?
Yes, and you, as it sounds like you will, Your Honor, ask the witnesses, we'll get more detail, but it is my understanding that it has been used, and it's been used in circumstances where there are errors with a meter, where a transportation customer is unable to establish how much they may have used in a particular month. Those sort of metering issues that have driven them. That's the special circumstances the company has used in the past.
And is that how the company is viewing those special circumstances? As for meter errors and meter errors alone?
That's certainly what they've used it for in the past, and that's what they believe it's appropriate for, yes.
And I'm asking, it says that's the sole discretion of Summit, but I mean, Summit received an extension of its ACA period, I believe, from how long? From 6 months or a year to 5 years, is that correct?
Yes, Your Honor. It requested that because the bill impact for its individual customers would have just been extremely high had they collected it over a 1-year period.
I guess I'm just wondering, why would that be a special circumstance by which Summit would get treatment to spread something out over a long period of time, but Summit does not consider Winter Storm Uri a special circumstance in regards to tariff sheet 37?
Well, the justification for spreading those under-recovered gas costs over 5 years as opposed to the collection over a 12-month period ultimately was the result of a tariff provision for the company, a separate tariff provision. So it had nothing to do with this provision on sheet 37 or even quote-unquote, the special circumstances as used here. Now, certainly that tariff provision was implemented with an eye towards Uri and the impact on on the customers that otherwise would have occurred in the absence of that provision.
Well, I guess I'm just trying to look at this from the point of these costs. The cash out costs are a result of Winter Storm Uri. And they are affecting one of your customers. So why does Summit not consider this a special circumstance?
In terms of sheet 37, we just don't believe that it fits into what was intended by special circumstance in that situation. Now, I will say that I don't want to leave you with the impression, Your Honor, that the company has maintained all along that it should be written a single check for the amounts that are due. I mean, the company certainly sees value to spreading costs over a period of time for Ozarks. And so again, I don't want to leave you with the impression that it's all or nothing for the company and how it has dealt with its customers.
Now, staff in their opening statement indicated that they supported a payment plan with a length of 5 years. If the commission ordered a payment plan, what would be the appropriate length of time?
I think we said in our statement of position no longer than 5 years, thinking about some of the issues that you raised, Your Honor, the fact that we have other customers that are under-recovered gas costs that are being spread over 5 years already for other customers. Now, having said that, one, I would point out that we're right now, April, May, 14 months past when this bill came out already. So we are effectively at least on a beyond 1 year payment plan already. And then the other thing I would note is that interest has some import to the other customers. And I think the longer your payment plan is, the even greater import that interest will have for other customers. So I think that aspect of it kind of goes hand in hand with the recovery time period that you're asking about.
Did Summit commit any violations that you're aware of in this case?
And we certainly take the position that the company did not.
Okay, give me just a second, please. Has Summit looked at what the potential customer impact would be if the commission granted an accounting authority order in this case?
We have not specifically, Your Honor, and I think for the same reason that maybe it was Ms. Myers that mentioned it, that, you know, depending upon what you assumed in terms of customer class impact and that sort of thing, it would drive different results.
Okay, thank you. Are there any questions from the commission? Go ahead, Chairman.
Thank you. I believe you testified earlier in your statement that there were other similar transportation customers that were out of balance that came back into balance by the end of the month. Is that what you said?
That's correct.
Is this case the only one that was not back in balance?
No.
There were other transportation customers not back in balance?
Correct.
And are any of them seeking any special treatment, or are they continuing to work through the existing tariff?
Working through the existing tariff or have already paid.
And to your knowledge, did Summit, did this company take, Ozark Medical, did they take any steps to get back in balance?
You probably should ask Chairman, my witness, Mr. Markham, would be better to answer that.
Okay, that's fair. Okay, thank you. I think that's all I have at this time, Judge.
Thank you. Are there any other commission questions at this time? Okay, hearing none, Mr. Cooper, may have a seat. And if there's nothing the commission needs to address at this point, and I don't hear anything, Ozark, you can call your first witness.
Thank you, Your Honor. Ozarks Healthcare calls Josh Reeves to the stand. Oh, Mr. Reeves, if you wouldn't mind sitting in the chair.
I apologize, we're not doing the podium. The witnesses have a seat over there. If you'll just stand there for just a second and raise your right hand to be sworn. Do you solemnly swear or affirm that the testimony you're about to give at this hearing today is the truth?
Yes.
Please be seated. Ozark, it's your witness.
Mr. Reeves, good morning.
Morning.
Would you please spell your name and state your name and spell it for the stenographer?
Yes, it's Josh Reeves, Josh. Last name Reev, as in Vicky, Es.
And by whom are you employed and in what capacity?
Ozarks Medical Center, doing business as Ozarks Healthcare, and I am the Vice President of Development and Advocacy and Director of Facilities.
And on whose behalf are you testifying today?
Ozarks Medical Center.
Are you the same Josh Reeves who caused to be filed direct and rebuttal testimony in this docket?
Yes, I am.
If I asked you the questions that are contained in that direct testimony, would your answers be the same or substantially similar?
They would be, yes.
And the same as to your rebuttal testimony, if I asked the questions that are contained therein, would your answers be the same or substantially similar?
Yes.
Do you have any corrections to make to your testimony at this time?
I do not.
Your Honor, at this time, I move for the admission of Exhibits 100P, 100C, 101P, and 101C. Respectfully, Josh Reeves' direct testimony, public and confidential, and Josh Reeves' rebuttal testimony, public and confidential.
Would you give me those numbers again, please?
Of course, 100P, 100C, 101P, 101C.
Okay, are there any objections to the exhibits that Ozark is offering for admission onto the record? Hearing none, exhibits 100P, 100C, 101P, and 101C will be admitted onto the hearing record. Go ahead, Mr. Hall.
Thank you, and I tender the witness for cross.
Thank you. Going by the order proposed by the parties, I believe public counsel gets the first cross-examination questions.
Thank you. Good morning, Mr. Reeves.
Good morning.
My name is Mark Poston. I represent the Office of Public Counsel. In this case, we represent the public in cases before the commission. And I just have a few questions. In your testimony, you say that you do not believe that the bill you received accurately reflects some of its costs to serve the hospital, OMC. Can you explain, is there anything specifically about that bill that you believe is inaccurate? Why do you believe it's not accurate?
Just from my understanding, that the majority of the bill, or some of the bill, is the tariff, the tax, not actually gas purchased to make up for the undernomination.
So you're saying you think it's not accurate because you don't believe that it's, that total amount includes all gas purchases that were made to make up for the needs that the hospital had? Is that accurate?
I don't know if that's the way that you stated that is accurate. So from my standpoint, and the hospital standpoint, we think the total bill isn't necessarily what it costs Summit to make sure that we had enough gas to supply service to the hospital.
Okay. And what is the basis for that? For claiming that you don't believe that was an accurate bill?
We haven't seen that amount from Summit or a breakdown necessarily the amount. That's why it was just a question.
Okay. And then, is it the company's position that Summit did not follow its tariff in assessing this bill?
Not necessarily, and I'll rely on counsel to answer that question. We are not experts on the tariff, and that, I think, is part of the problem here, is that it feels to us that that we don't quite understand fully what the bill was, so.
Okay. That's all I have. Thank you.
Any cross-examination from staff?
No questions, Judge.
Any cross-examination from Summit Natural Gas?
Yes, Your Honor. Mr. Reeves, I think it's in your testimony, Ozark Medical Center is located in West Plains, Missouri, correct?
Correct.
And you would agree that OMC is a transportation customer of Summit?
That is correct.
And as a result of that status, is it your understanding that Ozarks is responsible for delivering to the Summit system the gas that Ozarks will burn?
Through contract with a gas marketing company, yes.
And that's going to be my next question. OMC personnel don't do that themselves, do they?
They do not, no.
And as you said, you contract with a broker or marketer to perform that service on your behalf?
Yes, correct.
And is that broker or marketer Ozark Natural Gas?
It is.
Your Honor, I'd like to mark an exhibit at this time. Now, it's a confidential document, but I don't plan to ask anything that I think would force us to go in camera at this time. Would that be Exhibit 200, Your Honor?
Okay, would you describe Exhibit 200?
This is going to carry the title Brokerage Agreement.
And has that document been provided to the other parties?
Well, it came from one of the other parties, but I'm going to hand out copies to everyone. Yes, Your Honor.
Is there any party that hasn't seen this exhibit? And I see that OPC is indicating they have not. So why doesn't everybody take just a moment to look at it before I ask if anyone has an objection?
Sorry, Judge, what was the exhibit number on this one?
200, I believe.
200, okay, thank you.
I'll give everyone a few seconds. And this would be 200C, correct? It is confidential?
Correct, yes.
At this point, are there any objections to admitting Exhibit 200C onto the hearing record?
Well, only as a nature of course, I don't believe Mr. Cooper has laid the foundation for submitting this into the record at this time.
And you haven't asked to admit it yet, have you?
I have not.
My apologies. Go ahead.
Mr. Reeves, do you have what has been marked as Exhibit 200C?
I do.
Do you recognize that?
I do.
And is that the agreement that OMC has with Ozark Natural Gas?
It is.
Now, at this time, I would offer that exhibit, Your Honor.
Any objections to admitting Exhibit 200C, the brokerage agreement, onto the hearing record?
No objections, Your Honor.
And I see no other objections, so Exhibit 200C will be admitted onto the hearing record. Go ahead, Mr. Cooper.
Mr. Reeves, in your rebuttal testimony, you state the benefit of an AAO is that the commission can grant relief to both SNG-MO and OMC while minimizing the impact to consumers by spreading OMC's cash-out debt amongst all of SNG-MO's sales customers. Do you recall that?
I do.
Now, by all of SNG-MO's sales customers, I assume you include Summit's customers in Gallatin and Hamilton.
All of their customers, I believe, is what I put in the testimony.
So you would include Gallatin, Hamilton, Warsaw, Branson, Osage Beach, wherever Summit has customers, correct?
I'm not familiar with every location that Summit has customers.
Do you know what counties are in Summit's Rogersville rate area?
I do not.
Now, also in your surrebuttal testimony, you state that OMC is uniquely situated as the sole inpatient provider for an 8-county area, correct?
Correct.
And when you refer to 8 counties, you refer to 6 counties in Missouri and 2 counties in Arkansas, correct?
Correct.
And those 6 counties in Missouri are Howell, Oregon, Shannon, Texas, Douglas, and Ozark?
I believe so, yes.
Now, I guess you'd agree with me that Summit Natural Gas of Missouri does not provide service to Arkansas, correct?
I believe you are correct, but like I said, I don't know the extent of Summit's coverage area.
And so I guess similarly, it would not surprise you if you found out that out of the 6 Missouri counties that you identified, Summit only provides service to 3 of them, Howell, Texas, and Douglas.
Like I said, I'm not familiar with all of Summit's service area.
That's all the questions I have. Thank you.
Thank you. I have a few questions, and I'm going to remind everybody that if I start to ask something that people believe I ought to go in camera for, please let me know. Mr. Reeves, why did Ozark elect to be a transportation customer?
Primarily because of cost. That's the driving factor of it. The rates provided by the market are typically less than we would pay if we were a direct customer of Summit.
Did Ozark understand at the time they entered into this agreement? Did you understand the cash out provision?
The parties that signed the agreement no longer work for Ozark's Medical Center. It was signed in 2012. So I cannot tell you if they understood or didn't understand the cash out provision.
Do you understand the cash out provision?
I understand kind of on a global level the cash out provision, not necessarily all the details about the tariff.
Is this the only time that Ozark has been subject, and I'll just say OMC has been subject to Summit's cash out provision?
No, actually, I wouldn't say frequent, but it occurs a few times a year that we'll be subject to the cash out provision. But in the past history, it's usually, hundreds to a few $1,000s at the most.
How often do you adjust your contract usage? Or do you adjust your contract usage to avoid triggering the cash out provision?
That's a question that I would have to speak to the marketer about.
When was the last time you spoke with the marketer about gas usage and the cash out provision?
We have spoken to the marketer several times in the last year. Probably the last time we spoke to him was in the last 30 days.
Did you speak to the marketer prior to the February cold weather event?
I cannot recall specifically speaking to him about the cash out provision immediately prior to the February event.
Does OMC have any sort of gas hedging policy in place?
We do have an emergency backup propane system for use in cases of emergency or if there's a disruption in the supply.
Is that your only policy to address fluctuations in natural gas?
It is, yes, currently.
If OMC has to pay this bill in full, what will be the impact to OMC?
So Ozarks Healthcare is a community-based nonprofit hospital where the margin, I don't want to say profit, where the margin of our facility every year goes back into our organization. And paying this bill in full immediately would take away from something that would affect patient care. So if we have to pay $500,000, that's $500,000 that we don't have for ultrasound machines. It's $500,000 we wouldn't have for nurse bonuses, physician bonuses. We operate on very small margins at our organization, usually less than 5%. In the last couple of years, less than 1% margin.
And if this is an in-camera question, let me know. Is OMC currently solvent?
I would prefer that we discuss financial matters in a more confidential setting.
Fair enough, thank you. I will, at some point, go in camera and address that, but I'll address what I can without that. I'm a little curious because it wasn't really specific in the pre-filed testimony that I read. Why did the propane backup fail?
So we had a service technician that came the day that we were requested to curtail, and both staff of the hospital and the service contractor concluded that just because of the extreme cold, and we had also just had winter precipitation a couple of days before, that it was just the combined factors, mechanically it would not work after 8 hours of trying.
Has OMC ever had to use their propane backup before?
Yes,
And it functioned?
yes.
And how often is OMC's propane backup serviced?
So it's tested quarterly, and there's usually at least 2 times a year, and these are the federal regulations that we have to follow. We have to fully run our system 2 times a year off of the propane system, whether, emergency or not, just as part of a test.
Was it explained to you when they say that it failed because of extreme cold, what exactly that meant?
No, but I mean, I've been dealing with buildings and facilities most of my adult life, and when you have that sort of extreme weather, machines and equipment do fail.
And just for clarification, when you say fail, you don't mean that there was no propane on the property available?
No, I mean that there has to be an adequate pressure, an adequate mix of air and propane to be able to power the system, and those parameters weren't met in a way to be able to operate the equipment at the hospital.
Do you know if the propane reserves had been available and functioning, would it have been adequate to cover most of the gas overage in this case?
Without knowing exactly the volume of the overage and how much our usage would have been those 3 days, I would hate to speculate. I don't know the answer to that.
Under normal operating conditions, is the propane backup set to function a set amount of time?
Yes, 96 hours.
So it would not have covered 3 days under normal usage regardless? Well, it would have just covered.
It would have,
I'm
yes.
sorry, I apologize. My math is falling apart. Bear with me for just a moment. Now, when you say that it would jeopardize the services that are charged, or the service provided by OMC, in order to pay, oh wait, I think that's more of an in-camera question. Why don't we go ahead and go in camera? Anybody in this room who is not authorized to hear confidential information, I'm going to ask that you leave the room. Likewise, if you are on the WebEx and you are participating and you are not authorized to hear this information, I'm going to ask that you turn your volume off or exit the WebEx.
Your Honor, could we inquire about the identity of the call-in user?
We can, I'll need my glasses. Do we have, who has called into the WebEx via telephone? Okay, Commissioner Coltmeyer, will you speak again? Commissioner Coltmeyer, would you speak again? Okay, I believe everybody that is on the WebEx currently is authorized to hear this information. Okay, so are we in camera? Now, I hate to do this because I was hoping we could get to this, through this witness before taking a break, but it is now 11 o'clock and we've been going for a solid 2 hours. So I'm going to, at this point, take about a 15-minute recess, and we'll come back and we'll finish out your testimony, Mr. Reeves. So it is now 11:03. Why don't we all come back at 11:20, and we will go off the record now.